modification?
Yes, ma'am.
What modification?
One bail order after one other condition.
What happened?
Bailer credit card जो है वो
Credit card पे क्या है?
credit card बाहर चले गए, सूरत चले गए जी, एक अकाउंट कम है, that is Mossad is agreed to.
Are you on file IJ?
Let's see RMP.
Friday.
Actually,
Friday को सबको
may I mention also? Item number 49 also. This is a pre-filing matter, admission matter, which is first appeal also. Appeal also this case will be taken up.
Admission matter.
Admission.
तो admit करना
हाँ, so admit करना.
कहाँ है? Serial number?
49.
Serial number 49.
My client was rejected.
Admit. Rejection of claim के against में
First appeal, according to section 2 of the CPC law, to reject the rejection of the client is announced to be
issue notice to the respondents for which the requisite under speed post and ordinary process be filed by next Thursday.
no.
Call for the records from the concerned court. With this, the counsel for the petition submits that by the impugn order, the plaintiff has been rejected and short count is involved in this case. Pose this case for final disposal on 22nd June. No, 16 on 23rd June in supplementary process.
Second appeal was CF 51.
51 क्या है?
First appeal 239. Fresh filing application matter. This is against the judgment order passed in land reference case.
51 line. FA number 239 of 2026. Land acquisition matter, the learned counsel for the applicant has submitted that the matter arises out of land acquisition proceedings. Under section 30 of land acquisition. Admit, issue notice to the respondents under speed post and ordinary process, for which requisites be filed by next Thursday.
Personal service.
Personal service.
Tomorrow is the date for execution.
That's
The
the
amount
addition.
will be released, that is the anxiety.
That's the addition.
That's the गलत
Delay तो नहीं.
नहीं
The requisites be filed within 1 week.
I'll file it within 2-3 days.
Requisites be filed by Monday.
But no.
By Monday. At this call for the records from the concerned court, at this the learned counsel for the appellant has submitted that IA number 5567 of 26 has been filed for stay of further proceeding in the execution case number 8 of 2026 within bracket 211 क्यों लिखा ब्रैकेट में आइए
that is the number that has been written in the certified copy. Certified copy,
8 to 11
page 10 it may be seen. एक ही केस होगा, लेकिन कैसे वो नंबर लिखा हुआ होगा हमको पेज 10 में वही सर्टिफाइड कॉपी.
In the execution case arising out of award number 1, LR case number 1 of 2019 and LA case number 17 of 8889. ठीक है? 8889. He submits that tomorrow is the date fixed in the case. Tomorrow is the date fixed in the execution case. And if the amount is disbursed, the appellant shall suffer irreparable loss amount. He submits that a short date may be fixed, but disbursal of the amount to be seen. ये नोटिस करेंगे दोनों में, आईएन में भी और इसमें. Considering the approached submission, the disbursal of the amount in the execution case we state in the next date of hearing. Post this case on reopening after summer vacation on 8th of June. बस 8 ही जून तक आपको स्टे. The records we call for from the consultant. Communicate.
From this supplementary list, and we're reading for hearing item 2, WTL 2436 of 2009.
Yes.
Yes.
I can't hear you. इनका loud.
But what happens? Suddenly it has been listed for hearing today. I think yesterday it was at serial number 43.
It was listed yesterday. Nobody appeared yesterday.
Yes.
Case was called out.
Both of us will.
So, what should I do?
So,
Should I
I am
come
for
to
the
your chamber?
I am for the respondent work.
So,
So, what happens student in that I am not ready to be today.
कल डिसमिस कर देना चाहिए था. ज़्यादा अच्छा होता. आपको रेडी होने का जरूरत ही नहीं पड़ती. अपीलान तो टाइम नहीं मांग रहा. आपको क्यों परेशानी है? हाँ बताइए.
आपको respondent.
आप रेस्पोंडेंट है ना. आपको आप अभी सुनते सुनते आप तैयार हो जाइए. ठीक है. आपको हम टाइम दे देंगे आगे बढ़ने. जरा इनको सुनने दीजिए.
Annexure 1 is in the challenge that is at page 34, that is the award dated 28th of January 2009.
Yes.
Page 45, therefore I come to the conclusion that the action of the management in dismissing the concerned workman is not fair and justified, as he is entitled to be reinstated with full back wages accordingly and rendered the following award. The action of the management of SCL in dismissing Subodh Dorai from the service of the company is not fair and justified, so the concerned workman is entitled for reinstatement in service with full back wages and other consequential benefit, and the management is directed to implement the award within 30 days from the date of publication of the award. In this case,
What happens to workman?
अभी तो आप पढ़े नहीं थे. फाइल क्या हो?
Now died.
Workman has died.
Workman has died and
Substituted.
his wife. So reinstatement part is gone. Only remains is backward. Now the
आपको तो मीडिएशन में भेजे थे. आप तैयार ही नहीं.
okay.
It was sent for mediation, of course.
so this is a list of dates.
Settlement between the parties has failed.
Small list of dates.
Yes, please.
In this case, we have filed one affidavit as per the direction of the Supreme Court.
ये क्या list of dates है? ये कोई appeal to best हो रहा है? What kind of list of dates it is? In labor matter, in a case of dismissal, the first thing which the court would like to know as to whether there was any domestic inquiry and whether the domestic inquiry was found to be
Yes.
fair.
There was a domestic inquiry, and domestic inquiry was conducted, and he has accepted his guilt before the inquiry officer
Domestic-
in examination in chief and also in prosecution.
Just a moment. Domestic inquiry was fair and proper.
It has been held that it was not fair.
So उसका तो कोई material नहीं देख सकते.
हम खाली एक चीज दिखाना चाहते हैं कि एफिडेविट हम लोग
Was unfair by order dated 31/8/2026.
Yes. We have filed one supplementary affidavit dated 16/8/2020.
16/8.
2024.
What is this?
The petitioner, after dismissal, had approached the Honorable Calcutta
Challenging the order of dismissal.
after 15 years, and the court did not entertain the application. That is Annexure 1, page 6. Relevant is
This is writ petition number.
writ petition number 22533.
Petition number 225
533 bracket में W
97. Bracket में W.
ब्रैकेट में W. पेज नंबर 8 देखा
ये 6 में है. ठीक है, पेज नंबर 8 की देखते हैं.
हाँ, पेज नंबर 8 देखा. This is order dated 20th of February 1998.
22/1998. Okay.
And this was the ground by which there is a stay.
Read please.
Yes.
Read this.
The petitioner has questioned the order of dismissal from service in the above writ petition. By order dated 24th of June 1982, order, that is the order of dismissal, the petitioner was dismissed from service as he was found guilty of offence of grave nature. The inquiry was conducted against the petitioner and charges were held to be proved against the petitioner. After lapse of over 15 years, the petitioner has chosen to question the said order of dismissal, which is Annexure D to the writ petition. The above writ petition has been filed after 15 years of the order of dismissal. Therefore, for his own laches, the writ petition is
It has been
disentitled.
dismissed on whatever be the ground, but it has been dismissed on.
It has been. Thereafter, one appeal was preferred.
This is that appellate court's order.
Yes. That we have annexed.
Where?
That is Annexure 8, page number 58 of the writ petition. Page 59.
Read petition में page 59 तो नहीं है, 45 तक नहीं.
Okay,
आप इंडेक्स में देखिए कहाँ तक है आपका पेज नंबर.
हाँ.
रिट पिटीशन में 45 तक है, वकालतनामा है, उसके बाद
एक मिनट, उसके बाद we have filed one stay application in which it is based on. Stay application. Page 50.
पेज 15
9.
रनिंग.
Annexure 9. Page 59.
59 आपका मैच नहीं कर रहा, नॉट मैच कर रहा।
अच्छा कनेक्शन 9 है।
कहाँ पर देखें हम आपका connection?
स्टे एप्लीकेशन।
आइए इन्होंने हटा के रख दिया होगा भाई, यहाँ से आइए ऐसे हटाने का नहीं है, मतलब सब ऐसे इस तरह से मत हटाएं। रीड के बाद काउंट
आईए नंबर है 1722 of 2000। 1722।
आइए नंबर
1722 of
2009। एलपीए नंबर बताइए।
LPA नंबर
हम अपने रिकॉर्ड से देखेंगे, आपके
जी,
रिकॉर्ड से नहीं देखेंगे। आइए नंबर बताइए 1722
हाँ।
एलपीए का नंबर तो बताइए। कलकत्ता हाई कोर्ट का ऑर्डर शीट डिफेक्टिव है। आधा टाइम जो है ना डॉक्यूमेंट ही खोजने में हमारा बीत जाता है यहाँ।
कनेक्शन है।
इसमें स्टे पिटीशन में तो कोई एनेक्शन है ही नहीं। There is no annexation to the stay petition.
इसी पर ऑर्डर हुआ था, कोर्ट का ऑर्डर देखा जाएगा डेटेड 20
ऑर्डर हुआ था, लेकिन हमको तो फाइनल डिस्पोजल में ऑर्डर दिखना चाहिए ना। यस
स्टे पिटीशन का पेज नंबर 10 देखा जाएगा हम लोगों ने। स्टे पिटीशन का पैराग्राफ 16
पेज नंबर 10।
9 paragraph 16 it is submitted that respondent did not challenge the order of dismissal within the filing departmental matter after lapse of 15 years respondent number 2 challenged the order of dismissal dated such and such before Calcutta High Court by filing MAT number 4105 of 1998 bracket में CAW number 9640 of 99 before justice after hearing the parties rejected the said petition filed by respondent number 2 I order dated such and such, therefore the memo copy was filed before the division day after delay of 254 days, but the said delay was not condoned and according to the said memo copy stood rejected on the said score by order dated 24/2/1999 and उसको हम लोग कनेक्शन जी
The learned counsel for the petitioner submits that the order of dismissal is 24/6/1982. And the order of dismissal was challenged by the concerned employee before the Kolkata High Court
after 15 years
after 15 years in WP number 22533 of 1997, which was dismissed on 20/2/1998, against which LPA was filed before the Honorable Kolkata High Court.
LPA नहीं बोलता MAT बोलता है
appeal was filed before Honorable Kolkata High Court, and the same being barred by limitation of delay of 254 days was also rejected by the order dated 24/2/1999. He has referred to the amendments made in IA number 1722 of 2009, paragraph 16, and also placed the order of the writ court passed by Honorable Kolkata High Court and commits that the case was dismissed on account of delay and latches, and there was no scope for raising any industrial dispute arising out of the same order of dismissal.
And that same matter was suppressed before the.
He submits that this aspect of the matter was suppressed.
No, there was no question of suppression.
Achha,
He was a party in the
It is my submission.
writ petition as also in the appeal. So he had ample opportunity.
Achha.
So why the petitioner was suppressed?
Just a moment. The learned counsel submits that this aspect of the matter was suppressed before the learned labor court, and the court proceeded on merits.
And that reference was made after 19 years from the date of
And the
dismissal.
reference was made after 19 years
From the date of
from the
dismissal.
date of dismissal. The order of reference is dated 19/9/2001, which is after the dismissal of the petition before Kolkata High Court, and also after the dismissal of appeal arising out of the petition before Kolkata. The learned counsel has submitted that the award passed by the learned labor court directing reinstatement of the concerned workman with full back wages
Further, this reference was under
is
clause
fit to be
D
set
of
aside.
subsection 1 of section 2A, wherein limitation is provided of 3 years.
The learned counsel has also submitted that the reference was under clause D of subsection 1 of subsection 2A
The idea.
of section 2A to subsection 2A.
Section 2A,
Section 2A of the Industrial Disputes Act,
wherein
Wherein-
limitation is provided of 3 years.
a period of limitation of 3 years has been provided for an individual workman to raise industrial disputes. Right? He has submitted that this aspect of the matter has also not been considered by the learned labor court. I replied that.
2A का clause 3, subsection 3. The application referred to in subsection 2 shall be made to the labor court or tribunal before the expiry of 3 years from the date of discharge, dismissal, retrenchment, or otherwise the termination of service as specified in subsection 1. Subsection 3.
He has referred to section 2 capital A within bracket 3 of the Industrial Disputes Act 1946. He has also submitted that the workman has already expired. So therefore, otherwise also there is no question of reinstatement. What remains is only the back wages. इसके अलावा back wages में कुछ बोलना है?
हमको क्या बोलना है कि 2K में बोलता है कि what is industrial dispute. ये कभी भी मैनेजमेंट के पास में इंडस्ट्रियल डिस्प्यूट अपना कोई भी क्लेम नहीं रेज किए और डायरेक्टली फिर वो रेफरेंस के लिए2K industrial dispute means any dispute or differences between employers and
The learned counsel has referred to the definition of industrial dispute under section 2K and has submitted that since the concerned workman never raised any dispute with the management and therefore the reference itself was valid. That's all. क्या बोला? Respondent.
हम जजमेंट दे देंगे उसमें
दीजिए।
2K में। Page number.
The learned counsel has relied upon the judgment passed by Honorable Supreme Court in ये क्या है?
Same as the paragraph 28.
In AIR 1968 SC 529 and has referred to paragraph 4 of the same judgment. To submit that if no dispute is at all raised with the management, then any request sent by the concerned union/employee would only be a demand by them and not an industrial dispute between them and the employer. A mere demand to the government without a dispute being raised by the workmen with their employer cannot be an industrial dispute. And he submits that on the same count, the Honorable Supreme Court has held that the reference itself was reference made by the government was not complete. On the same principle, the learned counsel has relied upon the judgment. इसी को फॉलो किया है.
हाँ इवन सेक्शन 10 में भी बोलता है कि since limitation has not been provided, it should be within reasonable time. एक सुप्रीम कोर्ट का जजमेंट है 2015 वॉल्यूम 15 SCC. But that is with respect to section 10. It has to be filed within reasonable time.
एक ही चीज के लिए दो जजमेंट क्या
सिंपल एक ही सफिशिएंट
एक ही सफिशिएंट.
और एक ये है कि सेक्शन 10 में
The learned counsel has also referred to the judgment passed by Honorable Supreme Court.
हाँ सुप्रीम
Supreme Court reported in bracket 2015 bracket 15 SCC page 1 and has submitted that the term at any time as used in section 10 has been interpreted and it has been held that stale dispute cannot be referred for adjudication by labor court/industrial dispute. And in the same case, it was held that the reference having been made after 14 years of termination without any justifiable explanation for delay, the appropriate government had no jurisdiction or power to make reference of non-existing dispute.
वो section 10 के लिए
He submits that the said pronouncement was with respect to section 10 of the Industrial Disputes Act, where the government had refused to refer the dispute for adjudication. However, in the present case, the reference is under section 2 capital A of Industrial Disputes Act, and therefore it will be governed by the limitation as provided under section 2 capital.
it is 3 days.
That is 3 years. That's all.
Yes.
आपको क्या बोलना?
और एक सबमिशन
And or substance
इसमें वो
any other point which was
वो एडमिट कर लिया
कहाँ से
डिपार्टमेंट
बोले?
डिपार्टमेंट
Departmental proceeding has been held to be
हाँ वो
unfair.
ठीक है उस पॉइंट में
During the course of hearing, it transpired that the domestic inquiry was held to be unfair by the learned court by the order dated 31/8/2006. Yes, what do you have to say?
That whatever submission is made during the proceeding of the labor court, by filing the written statement, we cannot go away from that, beyond that. So these points are available to him, and when he has not asked these points, so now in the jurisdiction, they cannot raise all these points.
So the fact that you had moved before the Kolkata High Court, is it in dispute?
And no, it is not in dispute, but he has appeared in writ petition and also in
So it
appeal.
was his duty to.
So it was not a this.
Because it is not a case that he did not know about.
So he had ample opportunity to oppose the reference. He did not do so. Here in the writ petition he is raising these points, and he cannot go beyond the reference, beyond the predicts, which was submitted by filing written statement. And let's kindly consider that the case, what is the case? That only 160 रुपया का बोल की जिन लोग को बिल वेतन में कम दिया गया, वो फाइन नहीं हुआ, चार्जशीट हुआ.
नहीं हमको नहीं समझ आ रहा.
But what is the misconduct for which he was
Where is the
dismissed from
charge?
service?
Where is the charge sheet? Charge sheet पे कहीं? आपसे नहीं पूछ रहे. आप बताइए charge sheet का. Charge sheet.
Malad, what happens? Was there to So I am tracing it from the judgment itself, award itself. What was the
Just
case?
a moment.
What they have stated and what has happened during proceeding. The inquiry was found.
बताइए जजमेंट से आप क्या पेश करना चाह रहे हैं?
The written statement has been filed on behalf of the management stating that the reference is bad in law and not mandatory. It has been said that the present dispute on section 2A of the industrial dispute is not valid industrial dispute in the law. As a matter of fact, there is no dispute, much less any industrial dispute, and the same dispute to be dismissed illegally. The reference order is A suffers from the price of total non-abuse of mind by the government, and it is therefore vitiated. The sponsoring union has no understanding in the matter, as the so-called person is not its member and it is not competent to raise any
अब कहाँ
legal
पढ़
suit.
रहे हैं सर? Where?
हाँ रिव्यू स्टेटमेंट पढ़ रहा क्या?
अभी आप बोले इम्प्यून अवार्ड से दिखाएंगे.
हाँ रिव्यू अवार्ड का
पैरा नंबर?
रिव्यू अवार्ड का पैरा नंबर हाँ पैरा 2 हाँ पैरा 3
Just a moment.
पैरा 3 page 4 internal
Yes.
page 4 of the award reviewed award.
Yes.
The reference and order also puts the cart before the horse, and the public party is not required to take any action as envisaged in the reference order. The reference is also invalid for the reasons that no demand was ever made to the public party. The point in the alleged reference is specified for adjudication, and some deserves to be read subject to section 10(4) of the IDA, and the Honorable Tribunal shall have to confine its adjudication to this point. The question which is not directly raised in the reference will have not to be considered, even indirectly, while determining another matter, without prejudice to the aforesaid preliminary objection, and but strongly relying on the same, the employee did to submit their case on merit that no dispute was raised by the employee with employer. The concerned workman was a senior clerk posted at mid-side units of government employee to perform the duties of a paid clerk in the month of November and December 1980, January and February 81. In course of performance of the duty as paid clerk, he committed a serious misconduct of dishonesty, forgery, and violation of standing orders by paying less to some of the worker than their actual wages. During the aforesaid months, to cover up less payment, he interpolated the wage sheet and did not record the amount in the identity card of the workman concerned at the appropriate column. The concerned workman approached the management through their union, bringing allegation against the concerned workman for making a less payment to them to the tune of rupees 20 on each count at the time of payment by adopting various fraudulent means. The management deputed one R.D. Sharma and others to make preliminary inquiry. On the allegation made by the union, namely RCMS, and the workman concerned, on the basis of the preliminary inquiry, a prima facie case was established against the concerned workman. The charge sheet number dated 2011-381 was issued to the workman concerned, to which he submitted reply by letter dated 14/3/1981, denying the relation regulation. The management constituted a committee comprising of few persons to conduct the departmental inquiry on the charges leveled against the concerned workman by letter dated 16/3/1981. A hearing officer was also appointed by order letter dated 23/4/1981. The inquiry committee held the departmental inquiry after serving the notice to the concerned workman number of days in his presence. The departmental inquiry, the concerned workman was given full authority to appoint a co-worker to assist him in the defense. In prosecution, the management's witness to give his own statement and to produce the defense witnesses
Okay,
documents.
just a moment. there was a show cause, right? There was a domestic inquiry was held to be improper, but the management did not lead any evidence, and ultimately full back wages with clean statement has been given, right?
So,
In case, just a moment, in case where there is domestic inquiry and held to be improper, then full back wages is automatic, or you have to say that you were not employed somewhere else. Were you supposed to say that you were not employed somewhere else, or it is automatic? Is there any pleading or proof? First pleading, then proof that you were not employed anywhere else.
The inquiry officer submitted his report on 27/9/81 holding the concerned workman guilty of the charges leveled against him. The disciplinary authority, after consideration the inquiry reports, dismissed the concerned workman by level dated 24/6/82. The concerned workman accepted his review before the inquiry committee and also before the disciplinary authority, and he did not raise any dispute from the date of his dismissal till the present case, as he was fully aware of the fact that the dismissal was legal, bona fide, and justified. That is this. The concerned workman is in some cases did not mention the amount paid to the worker, and in majority of the cases, the concerned workman distorted the figure and actual amount by overwriting, and in many cases he paid less than the actual amount mentioned against their name, and in the wage sheet in the month of November 1980 and in the month of December 1980, in view of the aforesaid submission, the employer has paid before the tribunal that the action of the management is justified and concerned workman is not entitled to relief. In rejoinder to the written statement, the workman management, the workman has stated that the demanding point raised by the management has no legal leg to stand, and the same is being raised only to delay the proceeding of the case. It is also been submitted that the Honorable Supreme Court in pattern of cases held that the public sector undertaking management should invite adjudication of the case on merit in spite of raising technical and frivolous point to delay the proceeding of the case. The other thing are same and
इधर से
similar.
पढ़ के नहीं आए और पूरा का पूरा ऑर्डर पढ़ रहे हैं.
हाँ,
You just come to the point.
हाँ. The important point is para 4. Both the parties have adduced oral evidence by order dated
First tell me the references under section 10 or references under section 2A. There is no the union is not a party to the proceedings. Is union a party? You have made union their workman Janata Shramik Sangh. Award में तो नहीं लग रहा है. How is it there? Because written statement has been filed on behalf of the concerned workman.
Concerned workman.
Yes. And is there a separate written statement on behalf of the union?
No.
Then why union is a party here?
They are
workman code this number 2 this respondent was
Reference has been made under section 2A, right? 2A में there is a period of limitation prescribed.
subsection.
Under subsection 2 there is a period of 3 years. Subsection 2 is what we need.
the reasons based on to them it was not submitted during the proceeding, and also in the written statement. And they have also not stated that.
This is not a direct application to the labor code. This is by way of reference. So इसीलिए limitation इसमें नहीं लगी.
लेबर यूनियन assumes तो है.
Mr. Mukhopadhyay, I just want to know, the facts are very clear. After the inquiry was held to be improper, they did not lead any evidence. Right? So the labor court said that since they did not lead any evidence, there is no option but to reinstate, but with full backwards. I want to know, is it automatic or still you have to plead and prove that you were not gainfully employed anymore?
There was no dispute regarding that.
What? Why? No. There is no question of any dispute. That has to be there. And you say that your suppression is of no consequence. That I will take care.
It was
One last question.
Honorable Court has decided, and let's see.
Yes.
Non-council workmen also deferred circumstantial decision in which Honorable Court laid down that no reference can be rejected on the ground of billing. So there are so many decisions cited in the 9 of the judgment.
That is the first time.
And the total, what is the misconduct? There is also some workmen incur report only 50 rupees total in the month of November 20 and by December only rupees 110 on 160 come. That has been stated in para 10. So it shows that only what rupees 160 less payment is said to be given by the concerned workman in the preliminary income. It is according of the workman that due to trade union liability, the concerned workman had been first implicated on the complaint of rival union, which seems to be correct because as per inquiry report, it shows that on the complaint of the union, the inquiry has been set up against the concerned workman. So there was union, labor union conducting the case. Moreover, when the inquiry was held by my predecessor, not fair and proper, so it shows that the concerned workman was dismissed without fair and proper inquiry, and in that case, when no additional witness has been produced by the management, in that case, the management has
आपका submission लिखा है absolutely. Mr. Mukherjee, I'm recording your submission. कुछ छूटेगा तो हमको बताइए, ठीक है? The learned counsel for the just a moment. आपका लिखा रहे हैं कुछ भी छूटेगा तो आपको I will not stop. The learned counsel for the respondent has submitted that during the course of hearing, the learned counsel for the respondent does not dispute that the respondent workman had approached Kolkata High Court challenging his order of dismissal, and the writ petition was dismissed on account of delay and lapses. And further, the appeal against the same was also dismissed. However, he submits that the fact that the workman had moved Kolkata High Court was within the knowledge of the management, and therefore,
implicating the management as party,
and therefore, as the management was a party before Honorable Kolkata High Court, and therefore it was for the management to raise such objection before the learned labour court. The management, having not raised such objection, cannot raise such a ground for the first time in the repetition. He submits that at the stage of the repetition, only the perversity in the award is required to be seen. The learned counsel submits that since no such ground was raised by the workman before the learned labour court, under such circumstances, such ground cannot be raised by the counsel for the repetition before this court. He has further submitted that the industrial dispute was raised through reference by the government, and therefore section 2 capital A within bracket 3 does not come into play. Section 2A within bracket 3 comes into play only when the workman directly moves the labour court in terms of section 10 within bracket 2 of the Industrial Disputes Act. He has submitted that the law is well settled, that reference can be made at any time, and therefore the learned labour court has rightly rejected the plea of belated reference. The learned counsel further submits that the inquiry was held to be unfair by order dated, कौन सा order है? 2006. By order dated 31/8/2006. And management was given opportunity to lead evidence, but the management having not led any evidence, the court had no option but to reinstate the workman with full back wages. He submits that the learned court has also referred to the judgment passed by the Honorable Supreme Court in the case of Nita Kaplish versus Presiding Officer Labour Court, wherein it has been held by the Honorable Supreme Court that in the event the inquiry is held not fair and proper, and if the management fails to adduce evidence to prove the charge, then the workman is entitled to reinstatement with full back wages. The learned counsel submits that in aforesaid circumstances, there was it was irrelevant as to whether the concerned workman was gainfully employed or not during the period he was out of employment.
Definitely he was not gainfully employed because once application IA under 17B was filed and that was allowed.
The
and he
learned
was
counsel
paid.
has further submitted that a
So,
petition under section 17 bracket B of the Industrial Disputes Act was allowed by this court, and therefore there can be no dispute that the concerned workman was not gainfully employed during the period involved in this case. और तो छूट गया? Have I left out anything which you can argue? बताइए. The learned counsel for the respondent submits that he shall cite certain judgments post in view of the aforesaid submission, post this case for further arguments tomorrow. कल आप जजमेंट भी लेके आएंगे और हम जजमेंट दिखाएंगे, ठीक है? Okay. Do you get this?
कल लेके आएंगे.
तो आप भी कंक्लूड कर दें आप? चल लेते हैं, ठीक है? आपको बोले थे ना आपको हम टाइम देंगे, आपको दे दिए टाइम, कल आप लेके आइए.
one alternative argument on behalf of the respondent is that the period he did not raise dispute. So he is entitled for his back wages from the day he raised industrial dispute till he attains the age of 60 years. 2015 में 60 years से उनका पूरा हो गया वो जहाँ था he was paid.
And when did he raise the industrial dispute? 2001. 2001 में रेफर हुआ है.
रेफरेंस हुआ उसके बाद 99 में वो एप्लीकेशन दिया रिवायरमेंट 2010.
The Learned Council has further submitted that without prejudice to the aforesaid submission, at least the concerned workman should be entitled for back wages from the date he raised the industrial dispute in the year 1999 till his age of superannuation in the year 2015.
That is there. And so far the order of reinstatement, it automatically stands.
The Learned Council submits that there is no question of any reinstatement on account of the fact that the concerned workman has already expired and he also attained the age of superannuation.
That part is
He has attained the age of superannuation.
So now the widow, she is left only hoping for the amount of back wages.
Item 3, WPL 175 of 2010.
No illegality of publicity in the environment. The one recitation made by the Supreme Court 2015. There is latches because January 1995 it has been terminated and this award is of the year 2003. The point was raised.
No, I don't get it. You just tell me that in a case where a person is terminated, how and before and thereafter the reference is made, how the order of regularization can be passed. Unless there is the question of regularization will come only with respect to the persons who are working. It is one thing to say that during the period of pendency.
This matter was going on between.
From where you say this?
It has come in the.
बताइए ना कहाँ से 95 में termination हुआ.
95 में termination हुआ. Thereafter they revisited the matter. The matter was referred to. They were under section 9 this paragraph number 9 and the Learned Council of the Government. This case was referred to the tribunal. And here also this matter was referred to. Right? It was rejected. No, it was referred by the orders of the Honorable High Court.
Where is the order of the High Court?
It was by the page number 4 I am reading.
Page number 4 of the award.
It is from last lines of page number 53. The concerned workmen approached before the management several times for their organization.
Page number 4 of the award.
Page number 3, internet 47.
Page number
47. Last 3 lines, 47.
The concerned
workmen approached before the management several times for their regularization and wages as per NCW, but without any effect. Respected instances for regularization as an environment to the extent of terminating the service to the concerned workmen with effect from January 1995 by stopping them from work without any assigning any reason and without complying any mandatory provision of law. After exhausting all the venues for amicable settlement, in the meantime, the process was going on between both of them for amicable settlement between the union raised and industrial dispute regarding the concerned workman which ended in failure. Thereafter, government rejected the dispute illegally and arbitrarily at the instance of the management. This, against the illegal rejection order, was challenged before the Honorable High Court. As per order of the Honorable High Court, the dispute has been referred to tribunal for adjudication. It has been stated that the demand of the concerned workman for regularization and permanent status in the appropriate grade is legal and justified.
Where is the order of the High Court? Order of the High Court. डेट का नंबर बताइए, बताइए हाई कोर्ट का डेट है ना, नंबर बताइए. What is the read number?
WPL number 6195 of 2020.
WPL number
Number
6195
6195 of 2002.
Date of disposal?
8/6/2003.
Order का copy है?
Copy to me here, because I wanted to see also. It was not dated. Also from the date it was not possible to get from website.
WPL 6195 6195 of 2000.
The tribunal has considered whether very minutely or the evidence documentary and the evidence of the witnesses, and then came to the conclusion workman has never been sitting idle. Always my brother hesitated to use to before months. So, before the tribunal.
ऑर्डर जब तक नहीं मिलेगा तब तक हाई कोर्ट का ऑर्डर देना The learned counsel for the respondent workman has submitted that the reference itself was made pursuant to the order passed in WPL number 6195 of 2002, which was disposed of by the order dated 8/6/2003. However, the said order is not on record. Office is directed to place the records of WPL number 6195 of 2002. Close this case for further hearing tomorrow. कल आ रहे हैं मिस्टर मेहता, उसको को सुन के ही ऑर्डर कर देंगे. अब कुछ कल आ जाएगा ऑर्डर. ठीक है.
The citation is not quite different from the, because by the the citation is not applicable in the case of this.
Why is it not applicable?
Because by the we are hesitating to issue my regularly. And
Regularly means?
This pilot sees the date from the termination from the service, always, and up to date also, we were always raising this issue.
So where is it?
When they were developing were in service, they were always agitating the issue regarding their reinstatement in service, and after being frustrated by their
The whole point is, if the person has already been terminated, so can there be any regularization? That too from the date he was terminated.
from prior to the regulation, the issue is consistent, it is continuing. And when they have terminated, because they have terminated after being renewed, and they have no option, the government had no option. Then you
Then Workman should have challenged the order of termination.
termination challenged.
No, that is not challenged. That is not the terms of reference, whether the termination was victimization or termination was bad in law. You see the reference.
Whether the demand of the Janata Patrol Front from the arrangement to area for liberalization.
Yes.
Parliament to the Ashok Ram 29 other as per election is legal and justified, it's so hard to do.
Yes. You were seeking regularization.
But by your time, they were not allowing them to work.
That is not the case. It was your case only that you were terminated in 1995. You see, if there is a termination without following the procedure of law, then 25F will come into force. Isn't it? 25F will be there. Right? It will come. But how regularization will come into force? If there is a termination, arbitrary termination without notice and without following the procedure of law, then 25F will come into force. How in a case where a person has already been terminated, a person can be regularized? Terminated आदमी का कोई regularization होगा? ये पॉइंट आपका रेफरेंस ही गलत है. हाँ एकदम देखिए टुमारो ही कल ही वो ऑर्डर नहीं है तो हम आज ही लिखाते. मंगाए ना रिकॉर्ड.
From play list for final
Terminated
item 1.
आदमी का तो regularization नहीं होता unless the termination is satisfied.
Item 1 first appeal 101 of 2023.
इसी में रेस्पोंडेंट नंबर 3 देख कर दिए हैं पारा 27 ऑफ द स्टेट एडिशन में लिखे हैं which was filed in the year 2024. That will be what I take steps for substituting responsibility. But your lordship will kindly appreciate.
अब क्या हम appreciate करेंगे when you are not substituted?
ना वो 2022 से ही कहीं होता है. Next
तो क्या करें? Respondent number
3
कब डेट हुआ था?
देखिए 15/7/2024
किसमें लिखे हैं?
स्टेट पिटीशन पारा 27 से हम लगा हुआ डेथ सर्टिफिकेट स्टेट पिटीशन पारा 27
FA number 101 of 2023. The learned counsel for the respondent has submitted that as per the respondent number 1 and 2 has submitted that as per the state petition filed by the appellant themselves, the respondent number 3 has expired on 15/7/2024, but no steps have been taken by the appellant to substitute. He submits that the present proceeding has abated with respect to respondent number 3. क्या बोलना है सर? In view of the aforesaid fact, as disclosed by the learned counsel for the appellant, the proceeding against respondent number 3 has already abated. तो हम क्या करें
हम तो उसे खाली एक ही रिक्वेस्ट करेंगे 2024 से उसे ऊपर स्टे पिटीशन फाइल किया in spite our several effort by mentioning this matter before your lordships, but since the matter was admitted for hearing, therefore your lordships didn't want to hear it, the stay petition. तो बुजुर्ग का यही कहना था कि हम
आप ऐसा इसलिए नहीं बोल सकते हैं because there has been repeated adjournments upon payment of cost. Prayer for time is allowed as last chance. Prayer upon payment of cost of ₹1,000.
ये लोअर कोर्ट में हुआ ना?
जी नहीं, इसी कोर्ट में हुआ. इसीलिए इंस्ट्रक्शन पे मत बोलिए मिस्टर रॉय और काउंसिल साहब यू नो आपका वो जमाना खत्म हो गया
एक्चुअली बाद में है
इसीलिए बता रहे हैं इंस्ट्रक्शन पे मत बोलिए आजकल का जूनियर लोग कुछ भी इस पे इंस्ट्रक्शन देते हैं एनी इंस्ट्रक्शन
anyway I'll find it by tomorrow.
I just can't do anything about it. यहाँ पे अपलोडेड ऑर्डर सब भी नहीं देखते हैं सब अपलोडेड ऑर्डर
लोग के समय हुजूर भी सब था भी नहीं
अब अपलोड कराने का भी ऑर्डर होता है आपको लगता है it's a waste when the councils are not seeing the order which has been uploaded so I just can't do anything
हमको तो जूनियर लोग जो देता है वही हुजूर देखते हैं प्रैक्टिकली हम मानते हैं इस चीज को
सावधान हो जाइए सर अदरवाइज यू विल बी एट रॉन्ग
अभी हम सर को बताएं बाहर में कोर्ट के बाहर सर को बताएं
मत बोलिए अपलोडेड ऑर्डर भी लोगों को देखने का टाइम नहीं
सर बताएं तो सर भी बहुत अधिक सरप्राइज होंगे देख कर गए अपने सर आप ही थे बार 20 से
The council for the Pilan seeks adjournment. इतना आसान नहीं होगा आपके लिए सब्स्टिट्यूशन करवाना It will not be so easy. It is not going to be an easy sale because you yourself are disclosing the debt and the debt certificate.
yes now I take step not by tomorrow I will be filing it for the substitution
Post on 27 July.
तो वो लंबा डेट होगा
लंबा ही डेट होगा
तो सर दिक्कत क्या हो रहा है वहां पर
कुछ दिक्कत नहीं हो रहा जब तक
एग्जीक्यूशन केस में हमको टाइम नहीं देगा
नहीं देगा आपका जब एक प्रोसीडिंग अबेट हो गया है अभी हम कुछ कर ही नहीं सकते
और डिस्ट्रिक्ट जज क्या फाइल किए हैं एग्जीक्यूशन केस को ट्रांसफर के लिए
Item 2, First Appeal 257 of
थोड़ा सा
2026.
शॉर्ट डेट कर दो आफ्टर वेकेशन कर दिया थे
ठीक है 29 जून कर दो चलो
In this case, I am paying for 2 weeks. The hearing council has gone to favor of working.
इसमें एडजर्नमेंट आया था किसकी तरफ से
I am for the regular.
Who had filed the prayer for adjournment?
Because the file is with the Senate, my office, I am being counsel. 2 weeks time I am paying.
You are the plaintiff or the defendant?
Yes, I am. We are the plaintiff in the court. It's party order.
जब कर नहीं सकते तो क्यों देते इसमें?
मुझसे फाइल नहीं के पास है, मेरे पास नहीं है. He is out of station for treatment.
For treatment?
Yesterday I have listened to this.
क्या काउंसिल का नाम पता है?
Something like.
The learned counsel for the appellant has submitted that the arguing counsel, Mr. S. Naik,
Yes.
is not well, and therefore the matter may be adjourned. The up 2 weeks, near 2 years old. The suit was dismissed, although the proceeding was expected. Since the appellant अगले साल का कैलेंडर नहीं है इसीलिए इसी साल का डेट दे देते हैं. Since the appellant is seeking adjournment, post on 23rd December.
Yes, in that case, the substitution is so correct. They are already responsible.
आपको पिटीशन तो फाइल करना पड़ेगा ना.
इससे का तो हो तो बोलना. They are already responsible. इससे
ठीक है,
जरूरत
कोई
है.
बात
कोई नोटिस की जरूरत नहीं.
कोई बात नहीं आप करिए.
Item 3, first appeal 200 of 2024.
I was the plaintiff, we filed the claim for partition for property for self-acquired property that me and my brother, that is the current respondent, got from fund.
It is self-acquired property.
It's a self-acquired property, co-ownership. I am one of the co-owners, the respondent.
You are the plaintiff or the
I
defendant?
was the plaintiff.
Why your suit has been dismissed?
My suit has been dismissed, holding that I did not prove that I paid half share of the amount that was used in the consideration of this. The court has come to a finding that at page 14 of the judgment has come to a finding that it is evident from Exhibit 1 that plaintiff and defendant had purchased the suit property jointly. It has come to that finding,
Yes.
but later on it has come to a
Read
finding
it
that
further.
but the witnesses examined on behalf of defendant being the fathers and brothers of defendant and plaintiff. They have deposed that plaintiff has not paid single penny in the joint property through which the land was purchased in the name of plaintiff.
I am at internal page 13. Which page should I read?
Page 14 I was
1-4.
Page 13.
You read from page number 13. That would be better. Rather, just
before that the witnesses have been discussed. Page 13 is where we find.
why don't you read from page number 7? Let's see what are the witnesses. What is your point? I can understand.
My point is I issued safety which is Exhibit 1. It's a registered safety. Both our names are there on the safety. We have paid the equal consideration. Yet the London trial court without any basis has declined to declare half share of that property in mine on the ground that I have not proved how I paid one half of the consideration.
Is it mentioned in the recital that you pay half? You are
No.
paying half?
It's jointly.
It's jointly paid.
Jointly.
How this kind of judgment does not? Who is for the respondent? Respondent can. Proceeding is ex parte.
No, the trial court has.
Where is the respondent today? चलिए पढ़िए. You have any judgment on this?
I might refer to section 45 of the Transfer of Property Act.
Transfer.
Joint transfer for consideration, where immovable property is transferred for consideration to two or more persons, and such consideration is paid out of a fund belonging to them in common. They are, in absence of a contract to the contrary, respectively entitled to interest in such property, identical, as nearly as may be, with interest to which they were respectively entitled in the fund, and where such consideration is paid out of separate funds belonging to them respectively, they are, in the absence of a contract to contrary, respectively entitled to interest in such property in proportion to the shares of consideration which they respectively advanced. In absence of evidence as to interest in the fund to which they were respectively entitled, or as to the shares which they respectively advanced, such persons shall be presumed to be equally interested in the property.
Let us see the exhibit. Say it first. Exhibit number?
Exhibit 1.
Where is the consideration mentioned?
At page 3 of the statement. चूंकि बिक्री के वाला दस्तावेज का विवरण यह है कि तफसील प्रकाशित संपत्ति की वास्तविक मूल्य 60,000 रुपए हम लोगों ने घरेलू तथा अन्याय आवश्यक खर्चों के लिए आज आपसे ग्रहण करके यह तबादला के द्वारा तफसील प्रकाशित संपत्ति आपके हाथ बिक्री किया और विक्री संपत्ति से हम लोग के अधिकारी
ये हम लोगों के घरेलू तथा अन्याय आवश्यक खर्चों के लिए दिस इज विद रेस्पेक्ट टू द सेलर
डीटी सेलर आज आपसे ग्रहण
So there is nothing mentioned with regard to the source of fund.
Yes, but
It is silent with respect
Yes.
to the source of fund or to who has paid.
the vendor has also come in deposition saying that
Just a minute. आगे पढ़िए आज की तारीख से उपरोक्त संपत्ति पर
हम लोग के हर प्रकार की स्वत्व से संपूर्ण स्वत्ववान और दान बिक्री हस्तांतर आदि हर प्रकार की मालिक बनकर सालाना मालगुजारी उपरोक्त हिसाब से साल मालिक गोविंदा झारखंड सरकार को बराबर आदाय देकर हम लोगों के नाम खारिज कराकर आप अपने नाम से चेक दाखिला ग्रहण करके विक्री संपत्ति पर आप अपने स्वखर्चा से कच्चा मकान कुआं पेड़ बगान आदि तैयार करके स्वयं बसवास पूर्वक या आप अपनी इच्छा अनुसार वंश परंपरा में परम सुख से वो नकल करते रहेंगे तथा इससे हम लोग या हम लोगों के उत्तराधिकारियों में से किसी को कुछ भी हक और अधिकार न होगा करने पर बिल्कुल नाजायज नहीं करते। प्रकाश रहे कि विपरीत संपत्ति पूर्ण रूप से निर्विवाद अवस्था में है, इस पर कुछ आर या नए संयोग हस्तांतरण में नाम किया हुआ नहीं है, फिर भी किसी प्रकार की
ठीक है देखिए पेड रिटन स्टेटमेंट It was a suit for partition.
It's a small fraction. And the third page of the claim.
There is nothing mentioned about the consideration amount in the plaint.
In the claim, point number 2, that the said property was purchased by plaintiff and
That's just with respect to passing of consideration amount, nothing has been mentioned as to who paid and what is the consideration. Nothing has been mentioned. You just file a suit for partition. Okay, let us see the written statement.
from para 12. So far as para 20 is concerned, as partly admitted, plaintiff is addressing material facts. That the present property was purchased from the amount of order and other, but the plaintiff does not mention in claim the consideration amount, who has paid the consideration amount to the vendor of the said property. In the absence of such proof, the plaintiff has failed to establish this. So far as para
Just a moment. So far as 2 is concerned, which is partly admitted. Plaintiff suppressing the material facts that the present suit was purchased from the amount of father and other brothers. Father is the party here?
Father is not. Father has come and deposed in favor of the respondent defendant. There are other brothers in line of hierarchy. The plaintiff and defendant come at third and fourth brothers. So there are two other brothers, two elder brothers of plaintiff, who have not been made, who were not party to the same deal. Therefore, their name is not on the same deal. They are also not party in this.
So the consideration amount is said to be paid by the father and other brother.
So that is the story of the.
That is the story of the defendant.
No document to that effect.
Then para 7, reply to para 7. Para 15 people.
So there is also
Para
para 15
15.
very so this entire civil land is of 4 decimals, out of which 1.5 decimals was acquired by NHI. The compensation was deposited in the account of respondent, which he has transferred a part share of it to my wife's account.
Let's see para 15, read it please.
So far as para 5 of the claim is concerned, the answering defendant submits that 1.5 decimal land has been taken by highway. Then from that, some consideration amount has been given by NH authority, and the said amount has been credited in the account of defendant. It clearly shows that the bona fide purchaser of the suit property, as because the entire amount has been paid by answering defendant and his father, so no question arises to partition of the said property, and the plaintiff has not given any documents regarding payment of the said in favor of the lender, so the entire intention is nullified.
So therefore they say that the consideration amount to the extent of half share, which was acquired by NHA, has been paid to the wife of the plaintiff.
That 1.5 the amount received, he transferred half.
What is the total decimal area?
Total decimal is 4.
4. So 1.5, whatever was acquired by NHA,
70,000.
the compensation of that amount has been transferred to the account of the wife of the plaintiff. Entirely or part?
The entire amount was deposited in the account of respondent defendant. He has transferred half of the amount to the almost half of the amount to the
Out
wife
of that 1.
out of that total
So
amount.
he acknowledges.
Yes, that is my point. Even the trial court
He acknowledges
yes, that has been
that otherwise there was no scope for any transfer.
had it been an agreement or relinquishment agreement to that effect, it would have been a different case.
Or it was their case that there was no contribution
Yes.
from you, then this amount also would not have been transferred. So your half share is acknowledged. आगे पढ़िए. Para 17.
So far as para 7 of the plaintiff is concerned, the answering defendant submit that since the property has been purchased by defendant and his father's hard-earned money, so no question arises to sue the suit before this verdict court on this account. As the plaintiff is a clever person, just only the extortion filed with action suit. And there is no cause of action. That is the only defense that has been taken.
Now let us see these are the issues framed.
Page 5 of the
Within the family, the plaintiff got the amount directly from the co-sharer. There was no occasion for the plaintiff to raise any dispute before NHA.
and mere deposit of amount create a dispute before the NHAI.
Unnecessary. Okay. The plaintiff has been examined
Yes.
as PW.
4.
And defendant has been examined
Yes.
as BW.
BW3. He has acknowledged the payment that is made in my case. He has exhibited the entire parcel wherein multiple payments are mentioned.
Read his discussion in the internal page 12.
We also note that as per exhibit A, that is the passbook of BW3,
I'll see.
on 9/3/2017, the amount of highway compensation has been credited, and after that, 28/6/17, the amount has been credited in my share. It is after the amount.
And it is admitted that it was for risk property.
Yes.
Let us read. You read the discussion.
DW3, Santosh Malaka, defendant in his examination in chief, he has deposed that in 2011, he and his father has purchased the suit property through the registered sale, and plaintiff's name was mentioned in the sale. None of the payment was made by plaintiff at the time of execution of sale. He has also made a payment to plaintiff's wife, Pooja Devi, of rupees 1,20,000 in year 2017, check of 1,47,000. Plaintiff has constructed a double-story building over the suit property through his hard income, and he has made a payment of materials on different dates through account payment. And in this regard, he has presented his passbook, which is marked as Exhibit A. After obtaining the land by NHAI of 1.5 decimals, in which defendant had made a payment of 3,70,792 in this account. The land statement has been proved through passbook, which is again marked as Exhibit A. In his cross-examination, he has deposed that there are altogether 5 brothers. The entire compensation amount was given in the account of defendant. At the time of execution of sale deed, their brother's name was not mentioned as they were minor, which is incorrect, as has come in the cross-examination of DW1, the father of the parties. Then the court's finding has started.
It is evident. You read.
It is evident from Exhibit 1, which is a sale deed having number 568 of 2011, in which Ramesh Chandra Ghoshal, Ravindranath Ghoshal, and Amit Kumar Ghoshal. Amit Kumar Ghoshal is PW1, who has come and deposed in my favor, saying that half amount has been paid by me. Jointly executed the sale deed in favor of Santosh Malakar plaintiff and Dilip Malakar defendant. On the result of Exhibit 1, it is crystal clear that after receiving of the entire amount, the sale deed was executed in favor of both the brothers. After execution of the sale deed, plaintiff constructed a double-storied building, including shops, in year 2017. Plaintiff also made a payment of rupees 1,48,000. It appears he is strongly mentioned as
It is defendant.
defendant has also made a payment of 1,48,000 to Pooja Devi, who happens to be wife of plaintiff. Although witnesses examined on behalf of plaintiff has failed to prove the payment made by plaintiff as a consideration amount in favor of execution of sale deed, as not a single sheet of paper by plaintiff, nor the witnesses examined on behalf of plaintiff had stated that the consideration amount was paid by plaintiff.
This is contrary to PW1. This finding is contrary
Yes.
to PW1?
As well as no document to this effect has been because since
Need not be.
Yes.
Need not be. But the court says that not even a single witness has been examined to this
Yes.
effect.
That is
This is contrary to PW1.
Yes.
Let's have a look at that paragraph.
PW1.
Which paragraph he said that they was paid? PW1 is the executor of the sale deed, isn't it?
PW1 is the vendor.
Vendor. So that's important. Who received and who paid.
पैरा 5 यह कि उक्त राशि दोनों भाई मिलकर आधा आधा भुगतान किया खरीदने के पश्चात उक्त जमीन पर दोनों भाई मिलकर मकान एवं दुकान का निर्माण किया
क्रॉस में कुछ है?
He has rejected the suggestion made by the defendant that the amount has been paid by the defendant and his father at point number 19. ऐसी बात नहीं है कि इस जमीन के एवज में संतोष मालाकार एवं उसके पिताजी जमीन का मूल्य भुगतान किया
पैरा 28 देखिए.
दिलीप मालाकार 7-8 वर्ष पहले
पैरा 28, 25, 26, 25 sorry.
जमीन का मूल्य संतोष मालाकार और दिलीप मालाकार जमीन मालिक को 60,000 प्रत्येक इसमें उन 2,40,000 दिए थे
Plaintiff कौन है?
Plaintiff is Dilip.
So यहाँ पे भी बोल रहे हैं, right? Nineteen and 20. आगे पढ़िए तो. Not only this, even the witness examined on behalf of the defendant.
Not only this, even the witness examined on behalf of defendant, they all have clearly stated that the entire payment was made by defendant through cash, as well as check to the executant of the sale. And this factor has been very well deposed by all those witnesses in their examination in chief, and the plaintiff has
Just a moment. All the witnesses of the defendant were they present at the time of execution of the sale deed? The presence of the witness becomes relevant because one of the vendors of the sale deed is saying that it was paid by both. So his presence is absolutely acknowledged and admitted. Have these witnesses said that they were present at the time of execution of the sale deed, or they are just hearsay?
only none of the witnesses are. Only the defendant himself has stated.
Defendant himself has stated that.
Yes.
Where is that defendant's evidence? DW?
TW3.
DW3. Let's read it, please.
यह कि मैं इस बात का प्रतिवादी हूँ तथा वादी मेरे सगा भाई है और वादी द्वारा झूठा एवं मनगढ़ंत तथ्यों के आधार पर माननीय न्यायालय में प्रस्तुत वाद बिना किसी वाद हेतु का दायर किया है तथा प्रस्तुत वाद खारिज करने योग्य है। वादी पूरी तरह के अनुदोषों को पाने का दावा गलत है क्योंकि वादी द्वारा माननीय न्यायालय में प्रस्तुत वाद उद्देश्यपूर्ण भावना से काल्पनिक एवं मनगढ़ंत तथ्यों के आधार पर परेशान करने गया कि प्रतिवादी संतोष मालाकार एवं उनके पिता मालाकार द्वारा ही अपनी मेहनत की गाड़ी कमाई से वर्ष 2011 में मौदा तेहरी खाता 1660 जमीन छुट्टी और अन्य भाई के अव्यस्त होने के कारण केवल केवाला डीड में वादी का नाम दर्ज कराया गया है तथा केवल केवाला डीड नाम
ऐसा तो नहीं है, तो आप जॉइंट नेम से है।
Yes, I actually
जॉइंट नेम से है।
they are total 5 brothers. It has come to the deposition of the father. DW1 is Gagan Malakar, who is the father. The point number 12 of his cross examination says मेरे कुल 5 लड़के हैं। सबसे बड़ा लड़का का नाम अनिल, सुनील, अनिल, दिलीप, संतोष एवं दीनानाथ मालाकार। So number 3 and number 4 are the plaintiff members. Has further come in his deposition that he was paralyzed for 15-20 years.
I want to, because he was not present, I want to see the cross-examination of DW3. पैरा 22 दलील में ऐसा नहीं लिखाया कि जमीन के एवज में रुपया सिर्फ संतोष मालाकार ने दिया है। अभी मैं मैकेनिकल एवं रिकॉर्डिंग का काम करता हूँ, दिलीप मालाकार भी मैकेनिकल का काम करता हूँ। दलील में पिताजी का नाम नहीं। इसमें कहा है कि he said that the entire consideration amount was deposited in his account amounting to rupees the entire compensation amount, right? Para 29.
इसमें विवादित जमीन में से अधिग्रहण करने के उपरांत जो मुआवजा 3,70,792 प्राप्त हुआ वह कुल रुपया मैं अपने खाता में दबाया।
पैरा 9 देखिए, यह कि प्रतिवादी द्वारा वादी के धमकी से, पैरा 9,
यदि प्रतिवादी द्वारा वादी के धमकी से वादी की पत्नी पूजा देवी को जमीन के एवज में क्रमशः सन 2017 में 40,000 रुपये 3 बार यानी कुल 1,20,000 एवं वर्ष 2017 में वादी की पत्नी को पैसा उठाने के लिए चेक के माध्यम से 49,000 का 3 चेक कुल 1,47,000।
इसी का हो गया ना आधा 370 का,
यस।
राइट। अब समझ गए कितना एविडेंस है। अब इसका नोट्स बनाइए, रेस्पोंडेंट है, नोट्स बना के दीजिएगा। दीज आर द पोर्शंस दैट वी आर हाइलाइटेड, राइट। यू हैव नोटेड इट डाउन और नॉट नोटेड इट डाउन? आई हैव मार्क्ड इट, मोस्ट ऑफ देम यू कैन हैव अ लुक एट इट। यस रेस्पोंडेंट, बताइए क्या बोलना है?
इशू नंबर 6 कर दीजिए।
हाँ,
इशू नंबर 6।
इशू नंबर 6। इशू नंबर 6 क्या रहता है?
इसमें है इशू नंबर 6 में कि प्रूव नहीं किए हैं कि उनका एविडेंस टोटल या एविडेंस में कहीं भी कहा कि पैसा
एक सेकेंड, इशू नंबर 6 में कर ध्यान दीजिए। पेज नंबर कहाँ लिखा है? इश्यूज
जजमेंट का पेज नंबर 15 नोट्स।
जजमेंट का पेज नंबर, हाँ बताइए। कॉम्पनसेशन अगर सिर्फ नेशनल हाईवे ने किसी को दे दिया तो पैटी डिसाइड कर देंगे। You see, in the family, if somebody pays half the amount, तो क्यों कोई नेशनल हाईवे के पास जाके इशू रेस करे? ऐसा नहीं है, बात खत्म हो गया। दो भाई के बीच में आधा आधा होना तो एक आदमी को दिया, कोई नेशनल हाईवे अथॉरिटी को ये सूट थोड़ी डिसाइड किया है। इज इट अ जुडिशियल प्रोसीडिंग? यस। फिर ऐसे कैसे होगा? नेशनल हाईवे जिसको दे देगा उसका टैक्स डिसाइड हो जाएगा। एंड सिंस द अमाउंट वाज पेड, there was no occasion for the plaintiff to raise further dispute. फिर क्या बताइए? दोनों भाई राजी खुशी अपना पार्टीशन करेंगे कि कोर्ट का ऑर्डर देंगे? मीडिएशन फेल्ड वंस, ठीक है, हम कोर्ट से ऑर्डर कर देंगे क्योंकि ये चल नहीं रहा है, जम नहीं रहा है। आज वेडनेसडे है ना, फ्राइडे को हम रख देते हैं। उनको ये यूट्यूब दिखाइएगा और पूछिएगा कि करना क्या, ठीक है? अगर तैयार होते हैं तो ठीक है, लेकिन ऑर्डर तो जो प्राइमरी फेसी हमको लग रहा है, और बाकी नोट आप फाइल कर दीजिए, कल तक कर दीजिए सब। ज़्यादा कुछ है नहीं, कर देंगे ना। और आपको इशू नंबर 7 के अलावा आपके पास कुछ नहीं है बोलने के लिए। सेल डीड में नहीं लिखा है कौन पेमेंट किया। जो आदमी पैसा लिया वो बोलता है कि दोनों आदमी ने पेमेंट किया, करेक्ट है ना? और बाकी लोग तो सब हियर से हैं। पिताजी बोलते हैं हम पैसा दिए, वो बोलते हैं हम पैसा दिए। जब सेल डीड हो रहा है तब कौन प्रेजेंट है इज इम्पोर्टेंट। हु इज मेकिंग पेमेंट एंड हु इज टेकिंग द पेमेंट, हु इज मेकिंग द पेमेंट, दीज आर इम्पोर्टेंट। और सेल डीड में कुछ नहीं लिखा है तो हम लोग कहाँ से नया कहानी शुरू करें? Heard the learned, थोड़ा सा लिखाते हैं, ठीक है? Heard the learned counsel securing on behalf of the parties. This appeal has been filed against the judgment and decree dated 16/1/2024 within that with decree signed on 25/1/2024 passed by learned civil judge within that with senior division bracket close 1 Dhanbad, whereby original suit number 68 of 2021 has seeking partition of the suit property has been dismissed. The learned counsel for the appellant, while referring to the plaintiff, has submitted that it was the specific case of the plaintiff that the suit property was purchased by the plaintiff and the defendant in the year 2011 by registered sale deed number 568 dated 21/2011, registered at Registry Office Chas Bokaro, and thereafter both the parties constructed 4 shops and residential house for 4 shops under first floor and residential house on second floor, and are presently running the shop and residing over the property with their family members. It was further case of the plaintiff that the total area of the property was area 4 district, plot number 1366. And out of the purchased property, 1.5 decimal was acquired by National Highway, and the all compensation amount was invested in the building work over the same property. It was a specific case of the plaintiff that the plaintiff is entitled to half portion of the property which was remaining after deducting 1.5 decimal. There was some dispute between the parties and the defendant denied partition. Ultimately, the suit was filed seeking partition of property in Khata number 21, plot number 1366, area 2.5. The suit was contested by the sole defendant, who opposed the prayer, and it was the specific case of the defendant. No, it was not. However, it was not in dispute that the property was purchased in the name of the plaintiff and the defendant. However, it was alleged that the plaintiff had suppressed that the suit property was purchased from the amount of father and other brother, but the plaintiff had not mentioned regarding payment of consideration amount of the land, and as to who paid the consideration amount to the vendor of the property. And it was asserted that in absence of any proof regarding payment of consideration by the plaintiff, the plaintiff had failed to establish the case. it was further asserted that the entire construction was done by the defendant and his father, and there was no question of giving any share over the suit property to the plaintiff. The defendant also referred to acquisition of 1.5 decimal of land by National Highway and asserted that the entire amount of compensation was credited in the account of the defendant, and that by itself showed that the defendant was the purchaser, was the bona fide purchaser of the suit property, as because the entire amount of compensation was paid. Bona fide purchaser of the property, as the entire amount of consideration was paid by the defendant and his father. It was asserted that the plaintiff had not given any document regarding the payment of the consideration of the sale deed in favor of the vendor, and therefore the entire contention of the plaintiff to claim half share is nullified. The following issues were framed by the learned trial court. Both the parties led oral and documentary evidences. The sale deed in question being registered sale deed number 568 of 2011 was Exhibit 1, in which Ramesh Chandra Ghoshal, Ravindra Chandra Ghoshal and Amit Kumar Ghoshal were the vendors in favor of Santosh Malakar, the plaintiff, and Dilip Malakar, the defendant. One of the vendors, namely Amit Kumar Ghoshal, sorry?
Dilip Malakar is the plaintiff.
Okay, Dilip Malakar plaintiff hai, and Santosh Malakar defendant. There is an error in the improved judgment. You have to take care. Defendant hai, this is plaintiff. Amit Kumar Ghoshal, one of the vendors, has been examined from the side of the plaintiff as PW1. The plaintiff has been examined as PW4 and the defendant has been examined as DW3. The father of the plaintiff and the defendant has been examined as DW2, DW1. DW2 is the brother? Not there. Is the brother of the plaintiff and the defendant. And so far as PW2 is concerned, she is Pooja Devi, wife of the plaintiff.
2 is wife of plaintiff.
2 is wife of plaintiff, and PW3 Shiv Kumar Malakar is the cousin of the plaintiff and defendant. That's all. और exhibits में और क्या क्या है? Okay.
Exhibit 1 sale.
You have the plaintiff has given only one exhibit. The plaintiff has the sole exhibit from the side of the plaintiff is Exhibit 1. So far as the defendants are concerned, they have exhibited Exhibit A, which is the passbook of the defendant, bank statement of the defendant, and that is only, which is the only documentary evidence produced on the part of the defendant. The learned court ultimately, the learned court firstly took up issue number 4 and 5 and decided the same against the plaintiff. So far as issue number 6 is concerned, the same was also decided against the plaintiff. While deciding issue number 1, 2 and 3, the same was decided in favor of the plaintiff. However, in view of the findings recorded in issue number 4, 5 and 6, the suit was dismissed.
Issues number 1, 2 and 3 were also decided against.
Accordingly, these issues are okay. No cause of action. The learned court decided all the issues against the plaintiff, and ultimately the suit was dismissed. The learned counsel for the appellant, while challenging the impugned judgment, has submitted that the learned court has failed to take into consideration that the sale deed itself did not disclose as to who paid the consideration amount. Rather, the sale deed indicated that the consideration amount was paid by the purchasers. It is not in dispute that the sale deed was executed jointly in the name of the plaintiff and the defendant. The execution of the sale deed and title of the execution of the sale deed and is not in dispute. He has further submitted that. He has further referred to section 45 of the Transfer of Property Act. And has submitted that the case would be guided by the aforesaid section. Section 45 is quoted as under. The learned counsel has submitted that one of the vendors of the property was examined as PW1, who has supported the case of the plaintiff that at the time of payment of the consideration amount, he was present over there, and both the brothers had made equal half portion of payment. He has also submitted that the evidence of PW2 the evidence placed on record clearly revealed that when 1.5 decimal of land was acquired by NHAI, though the entire consideration amount was credited in the account of the defendant, but he had himself, he had transferred through bank transaction 50% of the compensation amount. Almost 50% of the compensation amount in the name of the wife of the plaintiff. The learned counsel submits that the act of transfer of 50% of the compensation amount to the wife of the plaintiff itself reveals that the defendant acknowledged that the plaintiff had half share in the property. He has further submitted that he has further submitted that since half share of the property or half share of the compensation amount was transferred in the name of the wife of the plaintiff, so there was no occasion to challenge the payment of compensation amount by NHAI exclusively in the name of the defendant. He has further submitted that otherwise also payment by NHAI to defendant number 1 by itself is not arising out of any adjudication, and therefore this action by itself could not have been used by the learned court to hold that the defendant was the exclusive owner of the suit property, and that he has further submitted that the finding of the learned court in connection with issue number 6 whereby it has been observed that National Highway Authority, after proper verification, had granted compensation amount in favor of the defendant. And therefore, since the plaintiff did not raise any claim over the compensation amount or any objection in the matter of payment of compensation amount, adverse inference has been drawn against the plaintiff. The learned counsel submits that such approach to decide the title of the party on the basis of compensation amount disbursed by National Highway Authority is unknown in law, and merely because no objection as such was raised by the plaintiff at the time of disbursal of compensation, the same has no bearing in the matter in the light of the admitted fact that almost half of the compensation amount was already credited in the name of the wife of the plaintiff. He submits that once the plaintiff had received half of the compensation amount to his wife, there was no occasion to raise any dispute. The learned counsel has submitted that once the vendor of the property acknowledges that the payment was made by the plaintiff as well as the defendant, there was no occasion to hold that the payment was made exclusively by the defendant. He has also submitted that evidence of the father of the plaintiff and the defendant is also of no consequence inasmuch as he was not present at the time of execution of the sale deed, and it has come in evidence that he himself was paralyzed and dead. The learned counsel has referred to the examination in chief and the cross-examination of witnesses examined on behalf of the plaintiff and the defendant, and has submitted that in view of Exhibit 1 and the materials placed on record through Exhibit 1 and the materials placed on record, the plaintiff had proved half share over the suit property, and therefore the impugned judgment dismissing the suit on the ground that the plaintiff had, that it was only the defendant who had paid the consideration amount, cannot be sustained in the eyes of the law. That's it. The learned counsel for the respondent, on the other hand, has referred to issue number 6 and has submitted that the compensation amount of National Highway Authority, having been credited only in the account of the defendant, by itself, without any objection from the side of the plaintiff, itself reveals that the plaintiff had no claim over the suit property and he was just a name lender. He submits that such non-action on the part of the plaintiff, inasmuch as he neither claimed any compensation with respect to the acquired 1.5 decimal of land, nor raised any objection in the payment of compensation, has been rightly considered by the learned court to hold that the plaintiff was not entitled to any partition, as the plaintiff had not made any payment of consideration amount, though his name was included in the registered sale deed along with the defendant. That's all. Concluded. Reserve कर अब दिखा दिए इतना वो आप लोग प्लीज वो आप एविडेंस का जो पैराग्राफ है आप भी दे सकते हैं, आप यू आर करूँ मेंशन करने के लिए आप भी, अगर आपको कोई भी एविडेंस का कोई पर्टिकुलर पैराग्राफ देना है आप प्लीज प्रोवाइडेड बाय टुमारो, राइट? The learned counsel for the parties have undertaken to provide a short synopsis by referring to the materials which have been argued during the course of hearing by plaintiff. 18 में क्या है? अच्छा चलो
गार्जियनशिप माइनर का इशू
एक सेकंड रुक जाइए, एक जजमेंट करने दीजिए.
Supplementary is for judgment item 1 second appeal table 1 of 2006.
This appeal is allowed.
सीरियल 18 में उसमें गार्जियनशिप का मैटर था. उसमें गार्जियनशिप हमारे फेवर में रहा हुआ लेकिन विदाउट एनी विजिटेशन था. उसको हम स्मार्ट को चैलेंज कर रहे थे. ऑर्डर्स में था 7 डेज का डिले था, उसके चलते ऑर्डर्स में हो रहा है.
कहाँ है 7 वाला दिखाई?
सीरियल 18
आप 2:15 बजे क्यों नहीं मेंशन करते हैं इस तरह का चीज? गार्जियनशिप का मैटर में विजिटेशन राइट नहीं. आप कौन है, फादर है कि मदर?
फादर मदर इन लॉ है.
मदर इन लॉ.
हाँ मदर. और सॉरी
दादी नानी
दादी
दादी
दादी हैं. और ये लोग जो बच्ची जो है वो नानी और नाना के पास है.
और माँ बाप कहाँ है बच्ची?
माँ बाप जो है डेथ कर
दोनों
एक्सीडेंट में. हाँ
कितना एज है लड़की का?
जिस समय हम फाइल किए थे 1 साल 3 महीना था, अभी 11 साल, इतना साल हमको डिसाइड कराने में लग
नहीं
गया। और भी हमको रजिस्ट्रेशन
अब आप 4.5 बजे मेंशन करेंगे तो और 10 साल लग जाएगा डिसाइड करने में। कहाँ है आपका डिले है?
हाँ 7 डेज का डिले।
नोटिस हुआ है?
हाँ नोटिस हुआ है, हम लोग ऐसे
देखिए 4:45 बजे एक्सपार्टी ऑर्डर नहीं करना,
नहीं
कल करें,
कल कर दिया जाए, वही हम
इसको कल के लिए
नेक्स्ट पार्टी के लिए नहीं।
4:45 बजे हम किसी के एब्सेंस में ऑर्डर
नहीं
नहीं
बोलेंगे हम लोग।
क्या बोल रहे हैं आप?
Next, serial number 4, we have filed this first appeal against the preliminary. Another first appeal we have filed against the file. Both of them being had.
कौन सा दूसरा आपका नंबर?
Filing number 4900 of.
फाइलिंग नंबर एक स्लिप दीजिए, मेंशन स्लिप इनसे लीजिए और इसको कल कर दीजिए, एक टैग करके एक साथ पोस्ट, ठीक है? और वो एक आपका आप मिस्टर रोहित राहुल जी के साथ एक मैटर मेरा पाठहट चल रहा था, क्या हुआ?
First
वो
appeal
कहाँ है, मतलब वो गुम हो गया?
वो डेट उसमें काफी लंबा डेट चला गया. That it was last week posted था. उसके बाद अभी इस सॉर्टेड की जून में चला गया. पाठहट मैटर आर्गुमेंट्स कंक्लूडेड है साथ ही. First appeal 62 of 2025.
बताएंगे आप लोग, हम खोज रहे हैं कहाँ है फाइल, इनसे रोज पूछते हैं कहाँ है वो केस, कहाँ चला गया, डेट बताइए कब का, डेट कब का है थोड़ा?
First appeal 62 of 2025.
62 of 25 टाइड अप मैटर है ना वो?
नहीं, फर्स्ट जो आर्गुमेंट्स कंक्लूडेड था उसमें वो
इधर डेट देखिए भैया सर।